Welcome back to the deep dive. You know how sometimes you come across information that's dense, complex, maybe even a little daunting, but you know there are crucial insights hidden within?
Yeah, that's definitely the case sometimes.
That's exactly what we're tackling today. We've got, well, a stack of constitutional articles, the actual legal scaffolding that holds India's federal structure together. We're particularly focusing on how the union and states interact, govern, and importantly, share financial responsibilities.
Uh-huh.
Think of it as peeking under the hood of how the world's largest democracy actually runs, with all its intricate gears and levers.
And our mission, as always on these deep dives, is to extract those most important nuggets of knowledge and insight to give you that shortcut to being truly well-informed.
Exactly.
Today, we're really dissecting specific articles from the Indian Constitution. We'll be looking at their nature, scope, object, application, and of course, the fascinating legal interpretations and landmark cases that have shaped them over the years.
Right.
This isn't just about memorizing legal text. It's about understanding the living, breathing principles that underpin governance, fiscal federalism, and individual rights. We'll be like legal scholars and guides walking you through each provision.
Helping you connect the dots, find those aha moments.
Precisely. Uncovering those
It's
moments.
a dense topic for sure, no doubt about it, but don't worry, we're going to break it down, make it relatable, and ensure you gain knowledge quickly, but thoroughly without feeling overwhelmed. We want you to feel like you've been on an incredible legal journey by the end.
Indeed. We'll explore these provisions like legal scholars, really diving into their very essence, their purpose, how they apply in the real world, and critically, what the courts have said about them. Looking at the nature, scope, object, the whole package.
Okay, let's unpack this incredible legal journey. So we're kicking off with administrative relations, basically exploring how the union ensures its laws are actually implemented on the ground by the states. And Article 256 in particular seems like the absolute bedrock of this entire administrative relationship, almost a constitutional command, right?
It is. Article 256 is precisely that, a constitutional command. Its core concept is straightforward, yet, well, profound. The executive power of every state must be exercised to ensure compliance with laws made by Parliament and any existing laws applicable within that state.
So it's not just a suggestion.
Not at all. The real genius here isn't just creating a legal obligation. It's the constitutional safeguard, preventing legislative intent from just dissolving at the state border. It ensures India truly functions as a unified legal entity. It's the practical bridge, you could say, from national vision to local reality.
So if Parliament passes a law on, say, environmental protection, Article 256 ensures states can't just ignore it. But what if a state doesn't comply? What power does the union have then?
Well, that's where the two-pronged approach comes in. You have the state's unyielding duty to implement these laws, and then, on the flip side, the union's corresponding power to issue necessary directions to secure that implementation.
Okay.
The text itself is quite clear on this. It says, the executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament and any existing laws which apply in that state. And then it adds, and the executive power of the Union shall extend to the giving of such directions to a state as may appear to the government of India to be necessary for that purpose.
Ah, necessary for that purpose.
Yeah.
That phrase seems key. It grants the union some discretion, doesn't it?
It does. It grants the Union discretion to determine when and how those directions are needed. But the necessity has to be linked to ensuring compliance with the law.
That sounds like a powerful mechanism for the union. How does this article actually function in the grand scheme of governance? What's its nature, its object?
Its nature is primarily directive and supervisory. Its main object, its purpose, is to ensure the effective and uniform application of union laws. Critically, it prevents states from undermining parliamentary legislation and helps maintain a harmonized legal system across the country.
Which is essential, I imagine.
Absolutely. Think about it. If a central law on, say, public health standards was implemented unevenly, it would defeat the entire purpose, wouldn't it? The scope of Article 256 is comprehensive. It applies to all states and all parliamentary or existing laws within them. It reinforces the union's legislative authority, transforming national laws from, theoretical constructs into practically implemented realities. It's really essential for the unity and integrity of India's administrative framework.
Okay, can you give us a concrete illustration? How does this play out in a real-world scenario?
Sure. A classic example would be national food safety standards. If Parliament enacts stringent laws, the Union government, under Article 256, can direct state food safety departments to actively enforce them. That means conducting inspections, ensuring compliance in local businesses, things like that.
Makes sense.
Or another example. Imagine a pre-constitutional environmental law still in force that a particular state isn't adequately enforcing, maybe due to resource constraints or um, lack of political will. The union can then step in and direct measures for its compliance, ensuring environmental protection isn't just a patchwork across different states.
And if the courts weighed in on this, what happens if a state consistently fails to comply with these union directions? What's the judicial perspective?
Well, courts consistently uphold the union's power for law implementation under this article. While direct challenges solely under Article 256 are less common, its principles are definitely implicitly tied to broader federal accountability. A landmark case, though primarily concerning Article 356 President's Rule, is S.R. Bomai v. Union of India. This case is really important because it implicitly highlights the importance of state compliance with union laws.
How so?
The court indicated that a state's failure to comply with union directions, which are often rooted in Article 256, can be a factor, significant factor, in determining a breakdown of constitutional machinery. And that, in turn, could potentially lead to the imposition of President's Rule under Article 356.
So the consequences can be quite severe.
Exactly. What's fascinating here is how these seemingly distinct articles, 256 and 356, interconnect. They create this potent web of accountability, making noncompliance a very serious constitutional matter. The underlying legal principles or doctrines here are federal supremacy, specifically in the context of implementing union law, and also cooperative federalism, because ideally the aim is intergovernmental collaboration despite the directive power.
That really underscores the teeth behind this seemingly administrative provision. Now, Article 257. This one seems to go a step further than just ensuring compliance with existing laws. Yeah. What's the core concept here? Why did the framers feel it was necessary to include these specific powers?
Yes, Article 257 is indeed a significant expansion. Its core concept moves beyond just law compliance. It deals with proactive measures and ensuring states don't obstruct the union's executive functions or national infrastructure.
So not just doing what union law says, but also not getting in the way of what the union is doing.
Precisely. The framers foresaw critical areas where the national interest demanded more direct union control, or at least non-interference from the states. It's really about the non-impedance of union executive power, ensuring things of national importance can proceed smoothly, and it also addresses financial fairness when states incur extra costs for these special tasks.
So this is about strategic control for national interests. What are the specific areas it covers? What are the basic ingredients of this article?
Article 257 is structured into 4 crucial clauses. Clause 1 sets a general non-impedance principle. States must not obstruct the union's executive power, and the union can issue necessary directions to prevent this.
Okay, that's the general rule.
Then Clause 2 gets specific. It gives the union direct power to direct states on the construction and maintenance of communications declared to be of national or military importance. There's also a proviso clarifying this doesn't restrict Parliament's power over national highways or waterways or the union's defense functions.
Right, so communications roads, maybe railways, telecom lines.
Could be. Then Clause 3 empowers the union to direct states on measures for railway protection, railways being so critical nationally.
Makes sense. And the fourth clause.
Finally, Clause 4 introduces that crucial element of financial equity we mentioned. It states that the union government must compensate states for any extra costs they incur while carrying out directions under clauses 2 or 3. The amount is determined either by agreement or, failing that, by an arbitrator appointed by the Chief Justice of India.
That compensation clause is vital, isn't it? It ensures that pursuing national interests doesn't unfairly burden specific states financially.
Exactly. That's the object here. It ensures the smooth functioning of the union executive, allows for the development of critical national infrastructure vital for defense, security, and interstate communication, and secures national assets like railways. The salient feature is this proactive union control for strategic purposes rather than just reactive compliance seen in 256. And that financial equity in Clause 4 is key, acknowledging that national interests might impose significant unforeseen costs on states, ensuring they aren't unduly burdened beyond their normal duties.
Can you illustrate this with a few vivid scenarios? Like, how would these clauses apply practically?
Sure. For Clause 1, the non-impedance clause, Imagine a state government enacting a policy, maybe unintentionally, maybe not, that creates bureaucratic hurdles for a central investigative agency trying to probe a national level crime within that state. The union could, under 257, direct the state to remove those specific impediments. Under Clause 2, the union might direct a border state to construct or significantly upgrade roads vital for rapid military movement towards an international border, deeming those roads of national importance.
Right, for defense purposes.
Exactly. For Clause 3, if there's a surge in railway sabotage in a particular area, or intelligence suggests a major security threat to railway lines, the union could direct that state to enhance specific security measures, maybe increase patrolling, better station security, etc.
And the compensation.
Right. So if that state incurred significantly higher costs for building that strategic road under Clause 2 than it normally would for its usual road projects, perhaps due to difficult terrain or higher specifications, Clause 4 would entitle it to claim reimbursement from the union for those extra nationally mandated costs.
So it's about the balance of power, with the union taking charge in specific nationally critical areas, but also being fair financially. What legal theories are at play here?
The underlying legal maxims or doctrines here are primarily federal supremacy, especially in matters deemed of national importance. There's also the doctrine of implied powers, the idea that the union's power to function implies the power to ensure states don't impede it. And, of course, the principles of national security and defense are central to Clauses 2 and 3. While specific cases directly challenging Article 257 are less frequent, court decisions generally uphold the intent, emphasizing that union executive power should operate without hindrance in these strategic domains.
Now, for Article 257A, this one has a truly interesting, almost dramatic history. It's not even in force anymore. What's the story here? What lesson can we learn from its rise and fall?
Yes, 257A. Here's where it gets really interesting, constitutionally speaking. This was a pivotal moment, reflecting a sharp tension in India's federal structure. Article 257A was controversially inserted during the emergency by the 42nd Amendment in 1976.
The emergency period. Okay, what did it do?
It empowered the Union to deploy its armed forces, or any other force under its control, in any state for dealing with a grave situation of law and order. Critically, it bypassed state control. The core concept, as it existed, allowed the Union to unilaterally deploy its forces, and these forces were not subject to the superintendence or control of the state government.
That sounds like a significant erosion of state autonomy, especially since public order is typically a state subject under the Constitution, so it was quickly repealed then.
Exactly. It was repealed fairly quickly by the 44th Amendment in 1978, just 2 years later. This was largely due to widespread concerns about excessive union power and its direct encroachment on state autonomy in a core state subject.
So it was seen as overreach.
Definitely. The repeal was part of a broader effort to restore the federal balance after the centralizing changes made during the emergency era. This isn't just a repealed article, it's a powerful lesson, really, in constitutional checks and balances, and the value placed on state autonomy within India's federal system.
Right.
It's important to note, though, even without 257A, Article 355 still obligates the Union to protect states from external aggression and internal disturbance. This can involve deploying central forces, but generally it happens either upon state request or under specific emergency provisions without the kind of explicit unilateral power Article 257A had granted for law and order situations. Its trajectory really reflects the ongoing debate about the union-state power balance, especially regarding the deployment of central forces and the sensitive issue of law and order. #2, administrative cooperation and fiscal distribution.
That makes the shift in constitutional philosophy very clear. Okay, moving on to Article 258. This seems to be about administrative cooperation, almost a two-way street with the states, especially when read with 258A later. What's the main idea here?
Article 258 truly embodies administrative cooperation and efficiency. Its core concept is to allow the Union to utilize the existing administrative machinery of the states. This facilitates convenience and, importantly, avoids the need for the Union to create a duplicate bureaucracy everywhere. It essentially offers two mechanisms for the Union to delegate its executive functions down to the states.
So it's about getting things done on the ground without the Union having to build its own parallel administrative structure in every single state. How does this delegation actually happen? What are the basic ingredients?
It happens in two distinct ways. Clause 1 covers presidential entrustment. Here, the president can, but only with the consent of the state government, entrust union executive functions to that state or its officers. This is a consensual, sort of agency-based delegation where the state essentially agrees to act as the union's agent for specific tasks.
Okay, so consent is key for that one. What's the other way?
Clause 2 covers statutory delegation. Here, Parliament can, by law, confer powers and impose duties on states or their officers regarding union subjects. This can happen even without explicit state consent for the law itself, because the obligation arises directly from the force of parliamentary law.
Interesting distinction. Consensual versus statutory.
Yeah.
And once again, we see the fairness clause. What are the costs for states performing these delegated duties?
Yes, Clause 3 is crucial, just like in 257. It mandates that the union must pay for any extra administrative costs incurred by the state due to such entrusted or conferred functions. This amount is determined by agreement, or failing that, by an arbitrator appointed by the Chief Justice of India.
Right.
The object, the purpose of Article 258 is clearly administrative efficiency, avoiding duplication of effort and resources, and ensuring effective ground-level implementation of national policies. This highlights a very pragmatic approach. Cooperation is encouraged, but there's fair compensation for the effort involved.
Can you give us some real-world examples of how this works?
Absolutely. Think about a massive nationwide exercise like the national census. The president, with, say, Maharashtra's consent, could entrust certain aspects of data collection and enumeration specifically to officers of the Maharashtra government under 258.
Okay.
Or under 258, if Parliament passes an act establishing new national industry standards, a union subject, it could, by that law, confer inspection and enforcement powers directly onto state district magistrates or other relevant state officials, making it their duty to implement those standards locally.
And if that costs the state extra?
Then, if that state incurs significantly higher costs, maybe by having to hire new specialized inspectors to effectively implement that central act, Clause 3 entitles it to claim reimbursement from the union. There's a clear distinction in case law, too, like Gentil Amrit Lawshadhan VFN Rana, which define the scope of functions entrustable under 258 as purely executive, not legislative or judicial.
So Article 258 is the union delegating to the states. Now, Article 250A seems to be the mirror image, where states can delegate functions to the union. That really is a two-way street, isn't it? Underscoring cooperative federalism.
It is indeed the reverse delegation, and a key enabler of cooperative federalism. Article 258A allows the governor of a state, acting on the advice of the State Council of Ministers with the consent of the Government of India, to entrust functions related to the state's executive power to the union government or its officers.
So a state can essentially say, hey, union, you've got better infrastructure or expertise for this particular state-level task. Can you handle it for us?
Precisely. The core concept is voluntary entrustment from the state, but it always requires the union's consent. The union acts as an agent for the state in these cases, and expenses are usually borne by the state unless they agree otherwise. This ensures the union isn't forced to take on state responsibilities without its concurrence.
What kind of functions are we talking about?
It only deals with executive functions, not legislative power. For instance, a state might entrust the execution of a complex welfare scheme, perhaps one that requires significant coordination across state lines, to a union agency because that agency has better infrastructure or established networks. Or, for a smooth interstate river water management project, a state might entrust certain coordination roles to a relevant union authority, with the union's consent, just to ensure efficiency. This truly illustrates the principle of agency within federal relations, working both ways.
Now, Article 259, I understand this one has been repealed. What was its historical context? Why was it needed initially?
Article 259, yes, another repealed one. It concerned the armed forces in the former Part B states. It was repealed back in 1956 by the Constitution's Seventh Amendment Act.
And its purpose?
It was purely a transitional provision. It dealt with the process of integrating the armed forces of the former princely states, which initially formed the Part B states, into the Union's armed forces structure.
So once that integration was complete?
Exactly. Its repeal was a direct consequence of the States Reorganization Act of 1956, which abolished the whole A, B, C, D categorization of states and fully integrated these territories into the mainstream structure. With the full integration of these states and their forces, the article simply became redundant. It's a powerful reminder, as you said before, that constitutions are living documents, adapting to changing political and administrative realities as a nation evolves.
Absolutely, a constitutional artifact marking a historical transition. Okay, let's shift gears now to fiscal federalism and revenue distribution. Article 268 seems like a fascinating compromise. The union levies the duties, but the states collect and keep the money. What's the clever mechanism here?
Article 268 is indeed a clever mechanism. It's designed to balance the need for uniformity in certain taxes with the state's need for revenue. Its core concept is that certain duties, although levied by the Union Parliament, are collected and entirely appropriated by the states within their territories. Crucially, these funds bypass the Consolidated Fund of India altogether,
But they go straight into state coffers.
straight into the state's account where they are collected. It's a specific revenue source for states, but with a national standard set by Parliament. The text specifies such stamp duties and such duties of excise on medicinal and toilet preparations as are mentioned in the Union list shall be levied by the Government of India but shall be collected by the states. The proceeds shall not form part of the Consolidated Fund of India but shall be assigned to that state.
So the union sets the rules, the tax rates, maybe through acts like the Stamp Act, ensuring national uniformity, but the states get the immediate financial benefit from collection within their borders. What are these specific duties?
The scope is quite limited. It applies specifically to certain stamp duties mentioned in the Union list, Entry 91, List 1. Think of duties on things like promissory notes, bills of exchange, checks, insurance policies, etc. And it also applies to duties of excise on medicinal and toilet preparations containing alcohol or narcotics, Entry 84, List I. The object, the purpose is clear. It provides states with a readily available local revenue stream from these specific items, ensures uniform rates nationwide preventing confusion or arbitrage, and can contribute perhaps modestly to reducing state financial dependence on the union for these particular sources. So when you execute a promissory note in a state, the stamp duty you pay, although determined by a central act like the Indian Stamp Act, is collected by that state and becomes its own revenue.
It's a clever way to harmonize national policy with local funding needs. What about the broader tax landscape? You mentioned GST earlier. How does 268 fit in now?
That's a great point. While Article 268 remains active for these specific duties, it's absolutely crucial to acknowledge the dynamic evolution of India's tax landscape. The discussion around Article 268A, which was inserted to cover service tax but never fully brought into force, and then the massive overhaul brought by the Goods and Services Tax, GST regime, particularly through Article 269A dealing with IGST, represents a fundamental shift.
The GST changed things significantly.
Hugely. GST has subsumed many central and state indirect taxes, aiming for a simpler, unified system. This has inevitably changed the specifics of revenue sharing in significant ways, moving away from some of these older, specific assignment mechanisms towards a broader divisible pool under GST. So 268 is still there for its specific duties, but it's part of a much larger and now significantly different fiscal picture.
That's important context. Okay, Article 269 seems to be another crucial mechanism, particularly for interstate transactions, which, as you said, can be tricky to tax fairly.
Article 269, particularly as amended over time, addresses precisely that challenge. Its core concept, especially post-80th Amendment, is that the Union levies and collects taxes on the interstate sale or purchase of goods and also on the interstate consignment of goods. The net proceeds from these taxes, excluding those attributable to Union territories, do not form part of the Consolidated Fund of India. Instead, they are assigned to the states and distributed amongst them based on principles formulated by Parliament.
So the union acts as the central tax collector for these cross-border transactions. But the revenue is ultimately earmarked for the states. This prevents individual states from imposing their own, potentially protectionist, taxes on goods just passing through.
Exactly. That's the key objective. It prevents a situation where goods moving from state A to state C via state B get taxed multiple times, which would cripple interstate trade. The specified taxes here are on the interstate sale or purchase of goods, other than newspapers, and taxes on the interstate consignment of goods, which aims to prevent avoidance of sales tax.
How is the money distributed?
The union levies and collects, but the revenue is assigned to states, with the specific principles for distribution among states determined by Parliament. Parliament also holds the power, under Clause 3, to formulate principles for determining when a sale or purchase or consignment takes place in the course of interstate trade or commerce.
And the object here?
The object is multifaceted. Tax interstate trade effectively without creating state-specific barriers, ensure central collection for efficiency but with equitable state distribution, and prevent tax evasion that could arise from complex cross-border transactions.
And the practical impact of this has been huge over the years, hasn't it?
Yeah.
Especially with the Central Sales Tax Act.
Absolutely. Historically, Article 269 was the constitutional backbone for the Central Sales Tax CST Act 1956, which governed interstate trade taxation for decades. There were numerous landmark Supreme Court decisions interpreting it, cases like State of Travancore Cochin and Ores v. Shamuga Vilas Cashew Nut Factory and Ores, and Tata Iron and Steel Co. Ltd. VSR Sarkar, which helped clarify the complex principles of what constitutes an interstate sale.
But again, GST changed the picture.
Massively. It's vital to emphasize the impact of GST here. The integrated GST, IGST, levied on interstate supplies under Article 269A of the Constitution, inserted for GST, has largely superseded Article 269's historical application concerning CST. While Article 269 might retain some relevance for specific goods kept outside the GST framework for now, its primary historical role in taxing interstate trade has been transformed by the IGST mechanism. This is a major evolution, demonstrating again how constitutional provisions adapt to massive economic reforms. The underlying theories are fiscal federalism and principles of tax assignment.
That's a significant transformation indeed. Now, Article 271 introduces another layer to this, a surcharge for union purposes. This sounds like the union's financial safety valve, allowing it to raise funds purely for its own specific needs without having to share.
That's a very apt description. Article 271's core concept is precisely that Parliament can impose a surcharge on certain taxes, specifically those referred to in Articles 269, which we just discussed, and 270, which deals with the main divisible pool of taxes exclusively for union purposes.
And the key point.
The absolutely crucial part is that the entire proceeds from this surcharge form part of the Consolidated Fund of India and are not distributable to states. It acts as an escape clause, you could say, for the union when it needs dedicated, unshared revenue. The text explicitly starts with, notwithstanding anything in Articles 269 and 270, giving it overriding effect for this specific purpose.
So even if it's levied on top of a tax that would normally be shared with the states, the surcharge component bypasses that sharing mechanism entirely. It's the union basically saying, this extra bit of revenue is just for us.
Exactly. Its object is to provide the union with an elastic, exclusive revenue source for its specific needs, perhaps unexpected expenditure, national security concerns, or funding specific central projects. It gives the union additional financial leverage. It's important to distinguish a surcharge from the base tax. It's an additional levy, often temporary or for specific emergent needs.
Can you give an example?
Sure. Parliament might impose, say, a 10% surcharge on income tax for a year, specifically to fund enhanced national defense preparedness or a major national infrastructure drive like a high-speed rail network. The revenue generated only from that 10% surcharge goes entirely to the union government and is not shared with the states.
I can imagine states aren't always thrilled about this.
Understandably, it can be a point of contention in union-state financial relations, as states naturally prefer a larger overall divisible pool. Courts, however, have acknowledged the distinct nature of a surcharge separate from the underlying tax, as did in cases like Federation of Hotel and Restaurant Association of India versus Union of India and Kesoram Industries Ltd. Versus Commissioner of Wealth Tax, upholding Parliament's power and the non-shareability of surcharge proceeds.
Moving on, Article 272 is another one that has been repealed, correct? What was its role before it was removed? Why was it deemed redundant?
Yes. Article 272 was repealed by the Constitution 80th Amendment Act, 2000. Prior to its repeal, its core concept dealt with certain union excise duties taxes on goods manufactured or produced within India. The proceeds of these could be shared between the union and states if Parliament decided to do so by law.
So it was permissive sharing, not mandatory.
Exactly. It wasn't a guaranteed share for the states. It depended on Parliament passing a law to that effect. The reason for its repeal was quite significant and tied to broader reforms in fiscal federalism. The 80th Amendment implemented the recommendations of the 10th Finance Commission, which suggested creating a general divisible pool encompassing most central taxes. This was achieved by substantially revising Article 270.
So the new Article 270 made 272 unnecessary.
Precisely. With most central taxes, including many excise duties, becoming part of this broader mandatory shareable pool under the revised Article 270, the specific permissive provision of Article 272 became redundant. Its repeal represents a clear shift towards a simpler, more comprehensive, and arguably more certain revenue-sharing model in India's evolving fiscal federalism.
And finally in this group, Article 273, which sounds quite specific grants related to jute and jute products. This must be a fascinating glimpse into the transitional fiscal arrangements immediately post-independence.
It absolutely is a fascinating constitutional artifact, really showing how the Constitution dealt with specific historical economic realities. Article 273's core concept involved mandatory, time-bound grants and aid from the Union to specific jute-producing states, namely Assam, Bihar, Orissa, now Odisha, and West Bengal.
And why just these states and just for jute?
These grants were provided specifically as compensation for these states losing their share of the export duty on jute and jute products, which was a significant revenue source for them before the Constitution assigned export duties exclusively to the Union. This was a very specific provision reflecting historical commitments made during the initial phases of the Republic, recognizing the economic reliance of these states on jute export revenue at that time.
How long did these grants last? Were they permanent fixtures?
No, they were explicitly temporary. Clause 2 of Article 273 clearly defined the duration. These grants were payable for a maximum period of 10 years from the commencement of the Constitution, i.e. until 1960, or until the Union abolished the export duty on jute, whichever came earlier.
So they expired in 1960.
Correct. The grants largely ceased after January 25, 1960. The object was purely financial assistance for a defined transitional period to compensate these specific states for a historical revenue loss. While it's now largely of historical importance, it beautifully illustrates how transitional provisions and specific grants and aid were used in federal finance to smooth economic adjustments and honor prior arrangements during the nascent years of the Republic. It falls under the doctrine of transitional provisions in federal finance, #tag 3, fiscal management and intergovernmental relations.
That truly gives us a sense of the Constitution as a living, adaptable document, dealing with immediate needs and then evolving. Okay, let's move into fiscal management with Article 274. This seems like a critical procedural safeguard to protect state financial interests against potentially adverse parliamentary actions.
It is indeed a critical safeguard and a significant constitutional check on parliamentary legislative procedure in financial matters. Article 274's core concept mandates prior presidential recommendation before certain types of financial bills or amendments can even be introduced or moved in either House of Parliament.
Which kinds of bills are we talking about?
Specifically, bills or amendments that would 1. Impose or vary any tax or duty in which states are interested. 2. Alter the definition of agricultural income as used for central income tax laws. 3. Affect the principles on which revenues are distributed to states, like under Articles 269 or 270. Or 4. Impose any union surcharge, like under Article 271.
So basically, anything that touches upon taxes shared with states, affects state revenues indirectly, or changes how money is divided up.
Precisely. This is a vital preemptive measure. It ensures that national-level financial legislation explicitly considers its potential impact on state finances right from the very beginning, before the legislative process even properly starts. The text is quite strict. No bill or amendment shall be introduced or moved except on the recommendation of the president.
So the president acts as a sort of gatekeeper or a federal balancer in these sensitive financial matters, ensuring the union doesn't inadvertently or perhaps unilaterally undermine state budgets.
That's a very good way to put it. The president, acting on the advice of the Union Council of Ministers, serves as a crucial federal balancer here. The object, the purpose, is multifaceted. Protect state financial interests and autonomy, ensure the union executive formally considers the federal financial implications before proposing legislation, and promote fiscal discipline and, ideally, intergovernmental consultation.
Into prior recommendation, not something that can be fixed later.
Yes, its salient feature is this mandatory prior recommendation. This is unlike Article 255, which in some other legislative contexts allows a procedural defect, like lack of prior recommendation where needed, to be potentially cured by subsequent presidential assent. Article 274's insistence on prior recommendation for introduction or moving underscores its non-negotiable importance at the very initiation stage for these specific financial bills.
So give us an example.
For instance, a bill proposing to change the distribution formula for taxes assigned to states under Article 269, or one redefining agricultural income in a way that might impact state revenue from related sources, would absolutely require prior presidential recommendation under Article 274 before it could even be tabled in Parliament.
What about the judicial view on this? How strictly is this requirement enforced?
Courts consistently view prior presidential recommendation under Article 274 as a crucial procedural requirement. While debates might exist about applying principles from Article 255, the specific wording and clear intent of Article 274 protecting state finances from the outset suggests a heightened importance for this prior check in these particular financial bills. It's a powerful mechanism for checks and balances, specifically within financial legislation, rooted firmly in the principles of fiscal federalism.
Next up is Article 275, concerning grants from the Union to certain states. This seems like where the Constitution actively builds in mechanisms for social equity and targeted development, helping to level the playing field between states with different resource bases, isn't it?
Yes, Article 275 is precisely that, a crucial mechanism where the Constitution directly addresses fiscal imbalances and promotes national objectives through statutory grants and aid from the Union to states deemed to be in need. Its core concept is to provide for these grants, which are vital for reducing both vertical, the gap between Union revenue and state needs, and horizontal disparities between different states' fiscal imbalances.
So it helps states that might struggle financially.
Exactly. It's designed to help states that might struggle to meet their constitutional responsibilities or to fund specific developmental goals, ensuring a certain minimum level of public services across the country.
So some grants are general, based on overall need, and others are very specific, targeted perhaps for particular groups or regions, correct?
That's right. The article operates on two levels. Clause 1 outlines general statutory grants. It empowers Parliament to provide sums charged on the Consolidated Fund of India to those states that Parliament determines are in need of assistance. Importantly, it allows for different sums to be fixed for different states, recognizing varying needs.
And the specific ones.
Then, the provisos to Clause 1 carve out very specific mandatory grants. The first proviso mandates grants for promoting the welfare of scheduled tribes in any state and for raising the level of administration of scheduled areas within a state to that of the rest of the state. These require the approval of the Government of India for the schemes.
Okay, focused on tribal welfare.
Yes. And the second proviso mandates specific grants to Assam for its tribal areas, covering certain historical excess expenditure and funding development schemes approved by the Government of India. Clause 1A also deals with allocating Assam grants if an autonomous state is formed under Article 244A.
So the Finance Commission, which we'll discuss in more detail later under Article 280, plays a big role in advising on these grants, particularly the general ones.
Absolutely. The Finance Commission's role is pivotal here, especially for the general grants under Clause 1. One of its key duties under Article 280 is to recommend the principles which should govern these grants and aid. The object of Article 275 is multifold. Reduce fiscal imbalances, enable states to meet their responsibilities, promote specific national objectives like tribal welfare, and provide assistance based on objective criteria, primarily guided by the Finance Commission's assessments.
And these are statutory grants.
Yes, they are statutory grants, meaning they are provided for by parliamentary law, and importantly, they are charged on the Consolidated Fund of India. This means their payment doesn't depend on an annual vote in Parliament, giving states assurance of receiving these funds. For instance, based on Finance Commission recommendations, Parliament might provide annual grants to states consistently facing revenue deficits. Or the Union could provide specific grants under the first proviso for building schools or healthcare facilities in scheduled areas approved by the GOI, aiming to improve tribal welfare and bring these regions up to par. This highlights the principles of equalization and intergovernmental fiscal transfers.
Article 276 deals with taxes on professions, trades, callings, and employments. This sounds like a unique constitutional carve-out, granting a limited but independent revenue stream to state or local governance, even if it overlaps somewhat with income tax.
It absolutely is a unique carve-out and quite interesting legally. Article 276's core concept allows state legislatures and local authorities authorized by state law, like municipalities, to levy taxes on professions, trades, callings, and employments. The crucial point is that such a law is not invalid on the ground that it relates to a tax on income, even though income tax is exclusively a union subject under the Constitution.
So it allows states to tax the activity of working or doing business, not the income itself.
Precisely. It taxes the status or activity of engaging in a profession or employment. However, there's a significant limitation. The article imposes a constitutional monetary ceiling on the total amount payable by any one person per annum to the state or any one local authority.
A cap. How much is that?
The text in Clause 2 specifies, the total amount payable shall not exceed 2,500 rupees per annum. That's Rs 2,500 per person per year, payable to either the state or any single local body levying the tax. This cap was actually raised by the 60th Amendment in 1988. It was much lower before that.
So states can tax the activity of earning, but there's this strict cap to prevent it from becoming a full-blown income tax and significantly encroaching on the union's exclusive domain.
Exactly. Clause 1 explicitly uses the phrase, notwithstanding anything in Article 246 to create this exception. The object seems to be to provide a modest independent source of revenue for state and particularly local bodies, empowering them to tax local economic activities directly without needing complex sharing arrangements. It creates a limited concurrent taxing space.
Can you give an example?
Sure. A municipality, under authorization from the state legislature, might levy an annual profession tax of, say, Rs. 2,400 on all salaried employees working within its limits. Or a lawyer practicing in the state might have to pay a similar amount. As long as the total tax levied by the state or any single municipality on that individual doesn't exceed the Rs. 2,500 annual cap, it's constitutionally valid under Article 276. Cases like Schinder Brothers, etc., v. Deputy Commissioner Reicher and Ors, have judicially clarified the distinction between this kind of profession tax, a tax on the privilege or act of carrying on a profession, and a tax on income.
Article 277 is next, and it's titled Savings. This sounds like a pragmatic solution to ensure continuity of certain revenue streams during the immediate post-independence transition, preventing a fiscal vacuum, right?
Yes, Article 277 is indeed a pragmatic transitional and saving clause. Its core concept is to allow pre-Constitution state or local taxes, duties, cesses, or fees to continue being lawfully levied and collected, even if the subject matter of that tax now falls under the Union list according to the new constitutional distribution of powers.
So if a municipality was collecting a tax before 1950, and the power to levy that kind of tax shifted to the Union under the Constitution.
Article 277 allowed that municipality to continue levying that specific tax for the same purposes it was levied for before. This was vital to prevent a sudden collapse of revenue for numerous states and local bodies immediately after the Constitution commenced on January 26, 1950.
But is this continuation permanent?
No, and this is the crucial limitation. This continuance is only until Parliament provides to the contrary by law. The text is explicit. Any taxes, duties, cesses, or fees which, immediately before the commencement of this Constitution, were being lawfully levied, may, notwithstanding that those taxes are mentioned in the Union list, continue to be levied until provision to the contrary is made by Parliament by law.
So it's a temporary reprieve for states and local bodies, essentially a constitutional placeholder until Parliament steps in to legislate specifically on that subject, either continuing it, modifying it, or abolishing it.
Exactly. The object was ensuring revenue continuity, avoiding sudden fiscal disruption for subnational governments, and providing a smooth transition, allowing Parliament the necessary time to review the complex tapestry of existing taxes and legislate comprehensively. Its salient features include this temporary continuity of lawful pre-Constitution levies, but always reinforcing parliamentary supremacy to ultimately override or regulate these saved taxes. For example, a municipality might have lawfully levied a local cess on entry of goods, octroi, before 1950. Even if aspects of taxing goods later fell under the Union or concurrent list, Article 277 allowed that municipality to continue collecting that specific pre-existing octroi for its local purposes until Parliament passed a law specifically addressing it. In cases like Town Municipal Committee, Amravati v. Ramchandra Vasudev Chimot have discussed what constitutes such provision to the contrary by Parliament.
Finally, in this section, Article 278, another repealed article, I believe. Similar to 259 and 272, what's the lesson from its brief existence?
Correct again. Article 278, which dealt with agreements with Part B states regarding certain financial matters, was repealed by the Constitution, 7th Amendment Act, 1956.
What was its original purpose?
Its original purpose was, like 259, primarily transitional. It focused on the financial integration of the former princely states, which constituted the Part B states. It allowed the Union government to enter into specific agreements with these states for a period up to 10 years regarding the continuance of certain financial arrangements or grants that existed before the Constitution, or regarding the levying of taxes whose proceeds were covered by those agreements.
So another tool for managing the complex integration of the princely states.
Yes. Its repeal, along with the repeal of 259 and 306, and the abolition of the Part A, B, C state classification itself by the 7th Amendment, was due to redundancy. Once the state's reorganization process was concluded in 1956, and financial provisions were applied uniformly across all newly reorganized states, such special transitional agreements became unnecessary. Like the others, it's now purely historical but important for understanding the initial complexities of integrating these diverse fiscal systems into a unified national financial framework.
From historical puzzles to the very backbone of fiscal accountability now, Article 279 deals with the calculation of net proceeds. This sounds absolutely critical for ensuring transparency and preventing disputes over how much money is actually available for sharing between the union and states.
It absolutely is. Article 279's core concept is foundational for the integrity of the entire revenue distribution system. It designates the Comptroller and Auditor General of India, a CAG, an independent constitutional authority, as the entity responsible for ascertaining and certifying the net proceeds of any tax or duty.
And net proceeds means
Clause 1 defines net proceeds clearly. It means the gross proceeds of the tax or duty minus the cost of collection. The CAG ascertains this amount, or the part attributable to any specific area, and certifies it. And here's the crucial part. The CAG certificate is declared final.
final, no arguments.
Essentially, yes. This finality is crucial. It ensures transparency and accountability at a fundamental level of fiscal federalism and effectively prevents what could otherwise be endless disputes between the union and states over the actual financial figures being divided.
So we have an independent, authoritative arbiter for the actual amount of money that's going to be shared.
Yeah.
That must be a critical role in minimizing federal friction.
Indeed. The object is precisely that. To provide an accurate, impartial, and authoritative determination of shareable revenues by an independent body like the CAG. This prevents disputes, builds trust, and ensures smoother fund transfers. Clause 2 also allows Parliament or the President to regulate procedural aspects, like the manner of calculation, payment timings, and adjustments between financial years, providing operational flexibility.
So give us a practical example.
Okay, imagine a union tax whose proceeds are shareable with the states under Article 270. Before the money enters the divisible pool, the CAG first calculates the total gross collections, then deducts the verified costs incurred in collecting that tax. The remaining amount is the net proceeds. The CAG then issues a certificate stating this final amount. This certified figure becomes the agreed-upon base for distribution according to the formula recommended by the Finance Commission.
And judicial intervention in the CAG's findings. Is that possible?
Courts are generally very reluctant to interfere with the CAG's certificate declared final under Article 279. They would typically only intervene under exceptional circumstances, perhaps proven malefides or fraud, which are very high bars. This underscores the constitutional weight given to the CAG's independent role in ensuring fiscal accountability and transparency. The maxims here are fiscal accountability, independent audit function, and finality clauses.
Article 280 then introduces the Finance Commission, which you referred to before as the architect of fiscal transfers, and a balancing wheel. What's its core concept and why is it so vital for India's federal structure?
The Finance Commission is indeed a cornerstone institution, absolutely vital for the health of India's federal structure. Article 280 mandates its periodic constitution by the president, typically every 5 years, or even earlier if needed. Its core concept is to be an expert, quasi-judicial body tasked with making recommendations on the distribution of financial resources between the union and the states, and also amongst the states themselves. It also advises on the principles for grants and aid.
So it's the body that recommends how the financial cake is sliced and shared.
Exactly. It acts as a crucial balancing wheel in India's complex fiscal federalism, playing a critical role in ensuring equitable resource sharing and reducing financial disparities between the center and states and among the states themselves. Clause 1 details its constitution, a chairman and 4 other members appointed by the president. Clause 2 empowers Parliament to determine their qualifications and selection process by law.
What exactly does this commission do? What are its key functions, its terms of reference, beyond just general recommendations?
Its mandate, laid out in Clause 3, is extensive and profoundly important. It is required to make recommendations to the president on, first, tax devolution. This is perhaps its most crucial task. It recommends the distribution of the net proceeds of taxes that are to be or may be divided between the union and the states. This is the vertical distribution. And then it recommends the allocation of the state's collective share amongst the individual states. This is the horizontal distribution, taking into account various factors like population, area, fiscal capacity, fiscal discipline, demographic performance, forest cover, and tax effort.
Okay, vertical and horizontal sharing. What else?
Second, grants and aid. It lays down the principles which should govern the grants and aid of the revenues of the states out of the Consolidated Fund of India. These are the grants under Article 275 we discussed. This ensures financial assistance to needy states is based on objective, well-considered criteria, not political whims.
Right.
Third, local bodies. This is a crucial addition stemming from the 73rd and 74th constitutional amendments strengthening local self-government. The Finance Commission now also recommends measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats, rural local bodies, and municipalities, urban local bodies, in that state. Importantly, it does this based on the recommendations made by the State Finance Commission of that state.
So it connects national finance down to the grassroots level.
Absolutely. It creates a channel for strengthening grassroots financial autonomy. And fourth, other matters. The president can also refer any other matter to the commission in the interests of sound finance.
That's a huge mandate, covering everything from national-level tax sharing down to local body finances. It sounds like an incredibly complex and impactful role.
It is. The object is clear. Ensure fair and equitable distribution of resources, address both vertical and horizontal fiscal imbalances, promote sound public finance practices across all levels of government, and provide an objective expert assessment to reduce the scope for purely political bargaining in financial matters. Its recommendations, while technically advisory, carry immense weight politically and practically, forming the bedrock of intergovernmental financial transfers for a 5-year period.
So the latest Finance Commission report, for instance, would guide how taxes are shared for the next few years.
Precisely. It would recommend the percentage share of central taxes for states, the criteria for distributing that share among states, and maybe specific grants to address revenue deficits or particular developmental needs in certain states. The legal maxims here include fiscal federalism, intergovernmental fiscal transfers, and the principle of equity and equalization, all hallmarks of cooperative federalism.
So once the Finance Commission submits its recommendations, what happens next? Article 281 seems to deal with that, ensuring parliamentary oversight and accountability for how the government responds.
Correct. Article 281's core concept is all about parliamentary oversight and ensuring accountability in the fiscal transfer process. It mandates that the president must cause every recommendation made by the Finance Commission, along with an explanatory memorandum detailing the government's action taken thereon, to be laid before both houses of Parliament. This memorandum is often called the Action Taken Report, or ATR.
So the government can't just receive the report and quietly ignore the recommendations. It has to publicly explain its stance to the elected representatives in Parliament.
Exactly. That's the essence of the accountability mechanism here. The object is threefold. First, to formally inform Parliament of the Commission's expert advice. Second, to make the government accountable for its fiscal decisions in response to that advice. And third, to enable public debate and legislative scrutiny on these critical financial matters that affect the entire Federation.
How does this work in practice?
In practice, after a Finance Commission submits its report, say the 16th Finance Commission recently constituted, the President directs that the report, along with the Finance Ministry's prepared ATR, which details which recommendations have been accepted, which might be modified, and which, if any, are rejected, along with the reasons, must be laid before both the Lok Sabha and the Rajya Sabha. This tabling often leads to extensive parliamentary debate and discussion, highlighting the crucial principles of parliamentary accountability and transparency in governance.
Okay, Article 282 is about discretionary grants for any public purpose. This sounds like a highly flexible power, allowing governments, both union and state, to respond to diverse needs that might not fit neatly into their specific legislative lists.
That's a very accurate summary. Article 282's core concept grants both the union and state governments a broad power to make grants for any public purpose. And the key phrase here is even if the purpose falls outside their normal legislative competence, as defined by the lists in the 7th schedule.
So it offers significant flexibility.
Immense flexibility. It allows governments to respond to diverse, often emergent public needs that don't fit neatly into those predefined legislative boxes. The text explicitly states, the union or a state may make any grants for any public purpose, notwithstanding that the purpose is not one with respect to which Parliament or the legislature of the state may make laws.
So the union could, for instance, give a grant for something normally considered a state subject, like improving primary education in a specific region, and vice versa, without being constitutionally constrained by the legislative lists.
Precisely. Its scope is potentially very wide, limited primarily by the judicial interpretation of what constitutes a public purpose. The object is clearly to provide flexibility to respond effectively to public needs, enable grants to various institutions or organizations like NGOs, research bodies, cultural societies that may not directly fall under specific legislative powers, and facilitate spending on diverse areas like scientific research, arts and culture, social welfare programs, or crucially, disaster relief irrespective of the strict divisions in the Seventh Schedule.
Give some examples.
Common examples include the Union government making grants to national scientific research institutions, even if education is largely a state concurrent subject, or a state government providing grants to NGOs running adult literacy programs or supporting local artists. The Prime Minister's National Relief Fund and Chief Minister's Relief Funds, often used for immediate assistance during natural calamities, also operate under the broad umbrella of this power to spend for a public purpose.
What about judicial review for public purpose here? Can governments just declare anything a public purpose and spend money on it?
Not quite. While courts generally allow wide latitude to the government's discretion under Article 282, recognizing the need for flexibility, they can intervene. If the stated purpose is clearly private, or if the grant is seen as a colorable exercise of power, meaning it's disguised to achieve something else, or if it violates other constitutional provisions, like fundamental rights, the courts can strike it down. The Supreme Court, in cases like Rustom Kavaji Cooper v. Union of India, the bank nationalization case, helped define public purpose broadly as being for the general interest of the community, not just for individuals. Later, Custodia La Lakshmi Reddy v. State of J&K emphasized that all government actions, including spending under 292, must be for the public good and must not be arbitrary or irrational. The legal maxims here are the public purpose doctrine and the exercise of discretionary powers of government, reflecting the essence of a modern welfare state.
Article 290 is next. Adjustment for certain expenses and pensions. This sounds like it ensures that the government benefiting from a service, or the one responsible for a pension liability, actually contributes to its cost, even if the expense was initially charged elsewhere, right? It seems to be about fair burden sharing.
That's exactly the core concept. Article 290 provides a specific constitutional mechanism for financial adjustment between the Union and states, or sometimes even between different states. This adjustment applies to certain expenses, specifically expenses of courts or commissions or pensions that might be initially charged on one government's fund, say the Consolidated Fund of India, but actually serve the needs of another government or are attributable to service rendered under another government.
So it prevents one government from getting stuck with the bill when another government got the benefit or created the liability.
Precisely. It ensures fair burden sharing. The condition is that if these specific types of expenses, courts, commissions, pensions, are charged on one fund but serve the needs of or are attributable to another entity, then the beneficiary government or the government responsible for the service period must pay a contribution towards those costs.
And how is the amount decided?
The adjustment amount is determined either by agreement between the governments involved or, if they fail to agree, by an arbitrator appointed by the Chief Justice of India. This provides a clear, high-level dispute resolution mechanism. The object is clearly fairness in distributing financial burdens, preventing one government from being solely burdened when the benefit is shared or the liability belongs elsewhere.
Can you give us an illustration of where this might apply?
A classic example involves pensions for all India service officers, like IAS, IPS, who typically serve both the Union and various state governments during their careers. While their pension might initially be charged, say, on the Consolidated Fund of India, Article 290 provides the basis for claiming contributions from the concerned state for the period of service the officer rendered to them. The formulas for this are usually worked out by agreement. Another example could be if the Union appoints a commission whose work primarily benefits one or more specific states. An adjustment for the commission's expenses might be sought from those states under this article. Or, if a high court serves both a state and a Union territory, the Union might contribute towards its expenses.
So these are typically resolved through intergovernmental agreements or arbitration rather than ending up in landmark court cases on the article itself.
Typically, yes. These are matters usually handled through administrative and financial negotiations, or arbitration if needed. Hence, you don't find frequent landmark court judgments interpreting the nuances of Article 290 itself. The guiding maxims are clearly equitable cost-sharing, fiscal adjustment in federal systems, and arbitration as a preferred dispute resolution method in such intergovernmental matters.
Article 290A sounds remarkably specific: annual payments to certain debitum funds. This must be another one of those fascinating specific constitutional provisions reflecting historical commitments, perhaps from the time of state reorganization.
It truly is a unique provision, quite unlike the broader principles we've been discussing. Article 290A's core concept mandates specific fixed annual payments from the consolidated funds of two particular states, Kerala and Tamil Nadu, to specific Devaswom temple administration funds.
Fixed amounts written into the Constitution.
Yes. It mandates Kerala to pay 46.50 lakhs annually to the Travancore Devaswom Fund, and it mandates Tamil Nadu to pay Rs 13.50 lakhs annually to the Devaswom Fund, established for maintaining temples in territories that were transferred from the former Travancore Cochin state to Madras, now Tamil Nadu, during the state's reorganization on November 1st, 1956.
So these are mandatory payments, constitutionally protected, and directly support the administration of specific groups of temples.
Absolutely. Its nature is a specific, mandatory, and constitutionally entrenched financial obligation. The scope is very precise, named funds, fixed sums. The object is clearly the continuation of financial support to these particular religious endowments stemming directly from the arrangements made during the 1956 state reorganization, likely to ensure their stable functioning after the administrative and territorial changes.
How does this work practically?
Practically, the annual budgets of Kerala and Tamil Nadu must legally make provisions for these charged expenditures. They are not subject to the annual vote of the legislature. The respective Devaswom boards then utilize these funds for the maintenance and administration of the temples under their purview. Given its specific and historical nature, direct constitutional challenges to Article 290A itself are rare. It stands as an example of how the Constitution accommodated specific historical agreements related to religious endowments during periods of major administrative change.
Now for Article 291, Privy Purse Sums of Rulers. This is another repealed article, but its story and its repeal marks a really significant moment in India's journey towards becoming a truly democratic and egalitarian republic, doesn't it? What's the dramatic story here?
It absolutely does mark a significant moment. Article 291, as originally enacted, guaranteed the payment of tax-free sums known as privy purses to the former rulers of the princely states. These payments were part of the merger agreements or covenants they signed when integrating their states into the Indian Union after independence. These sums were constitutionally guaranteed and charged on the Consolidated Fund of India.
So a constitutional promise made during integration, why was it repealed? It sounds like it must have been a very contentious issue.
Indeed, it became highly contentious over time. These privy purses, along with other special privileges enjoyed by the former rulers, were increasingly viewed by many as anachronistic relics of a feudal past, inconsistent with the democratic and egalitarian ideals enshrined in the Constitution, particularly principles of social and economic justice. The argument grew that special privileges based purely on birth were unacceptable in a republic.
So the political mood shifted against them.
Strongly. This led to the dramatic repeal of Article 291, along with Article 362 concerning rights and privileges of rulers, by the Constitution 26th Amendment Act, 1971. This repeal marked a definitive break from the princely past and affirmed the principle of equality.
Wasn't there a major court case involved before the amendment?
Yes, absolutely. The government initially tried to abolish the privy purses through a presidential executive order in 1970. This was challenged in the Supreme Court in the landmark case of H.H. Maharajatiraja Madhav Rao Jivaji Rao Scindia Bahadur and Ors v. Union of India, popularly known as the Privy Purses case. The Supreme Court, in a significant judgment, struck down the presidential order, holding that the right to receive the privy purse stemmed from the Constitution itself, Article 291, and was a property right that couldn't be taken away by executive fiat without a constitutional amendment.
So the court ruling forced the government to amend the Constitution.
Precisely. The Supreme Court's judgment directly led to the government pushing through the 26th Amendment in 1971, which then constitutionally abolished the privy purses and privileges by repealing Articles 291 and 362 and inserting Article 363A to explicitly terminate recognition of rulers and abolish the purses. It showcases a powerful interplay between the judiciary, executive, and legislature in shaping India's constitutional landscape and its commitment to egalitarian principles.
That's a powerful example of constitutional evolution driven by political and social change. Okay, finally in this section, let's look at the borrowing powers of the Union and states under Articles 292 and 293. Article 292 covers borrowing by the government of India. This article seems fundamental to the Union's ability to finance its vast operations, everything from infrastructure to defense.
Indeed. Article 292 is the constitutional foundation for the Union government's borrowing powers. Its core concept empowers the Union executive to borrow money upon the security of the Consolidated Fund of India. Crucially, however, this power is not unlimited. It's subject to such limits, if any, as may be fixed by Parliament by law from time to time. This power also extends to the giving of guarantees by the Union government, again within limits set by Parliament.
So the executive has the power to borrow, but Parliament acts as the ultimate financial overseer, setting the boundaries for the national debt and guarantees.
Precisely. This structure provides the government with the necessary flexibility to raise resources for its budgetary needs, financing development projects, covering defense expenditure, managing fiscal deficits while ensuring democratic accountability and fiscal discipline through parliamentary control. The object is manifold: raise resources, manage public debt effectively, provide a constitutional basis for government guarantees, which are often crucial for large infrastructure projects, and importantly, ensure fiscal prudence via parliamentary oversight.
How are these limits set in practice?
Parliament sets these limits through specific legislation. A key example is the Fiscal Responsibility and Budget Management (FRBM) Act, which sets targets and limits related to fiscal deficit and government debt, thereby operationalizing the control envisaged under Article 292. The scope of borrowing is broad, covering both domestic sources like issuing government securities or GSECs, and external sources like loans from international institutions like the World Bank or Asian Development Bank, although external borrowing is further regulated by specific laws.
Okay, that covers the union. Then Article 293 covers borrowing by the states. This seems to define state borrowing capacity, but with significant union oversight, almost like a powerful lever for the union to maintain overall macroeconomic stability.
Article 293 indeed defines state borrowing powers, but in a manner that is more circumscribed than the union's, incorporating crucial union oversight. Its core concept is that states can borrow money, but only within the territory of India, upon the security of their respective consolidated funds. This power is also subject to limits set by their own state legislatures.
Only within India. So states can't borrow internationally on their own.
Not directly, without union government consent or involvement. That's a key difference from the union's power under 292. Clause 1 grants states the power to borrow within the territory of India and to give guarantees secured by the state CFI and within limits set by the state legislature.
Okay, what's the union oversight part?
This comes in clauses 2, 3, and 4. Clause 2 allows the union government itself to make loans to states or give guarantees for state loans, subject to Parliament's limits under Article 292. But the critical restriction is in Clause 3. A state may not raise any new loan without the consent of the Government of India if there is still outstanding any part of a loan which has been made to the state by the Government of India, or in respect of which a guarantee has been given by the Government of India.
Wow. So if a state owes the center any money, or if the center has guaranteed a state loan, the state needs the center's permission to borrow anything new. That's quite a constraint.
It is a very significant constraint and a powerful lever for the union. Furthermore, Clause 4 clarifies that the union government can impose conditions when giving such consent.
That's quite a significant level of control over state finances, and I imagine often a point of debate in federal relations.
It is undoubtedly a major point of federal debate. The object behind this structure is likely twofold. First, to enable states to raise resources for their own development and administration needs from domestic sources. Second, to ensure national oversight for maintaining overall macroeconomic stability, preventing excessive borrowing by individual states that could destabilize the national economy, and to protect a union's own financial interests as a lender or guarantor to the states.
How does this play out?
In practice, state governments frequently raise funds by floating state development loans, SDLs, in the domestic market. However, if a state has an outstanding loan from a union scheme, perhaps from the National Small Savings Fund, NSSF, it would technically require union government consent under Article 293 before undertaking new market borrowings. The interpretation and application of this consent requirement, especially concerning borrowings by state-owned enterprises and whether they count towards the state's limit, has become a contentious issue.
Yes, I recall hearing about that.
Exactly. Recent disputes, like the one involving the state of Kerala taking the union to the Supreme Court, State of Kerala versus Union of India, original suit number 1 of 2024, highlight the continuing relevance and the complex legal and fiscal questions surrounding the application of Article 293, particularly the scope of borrowing and the conditions for union consent. The legal maxims here are fiscal federalism, intergovernmental debt and financial relations, conditional fiscal transfer assistance, and the overarching goal of macroeconomic stability. Hashtag SHAG-V, property, contracts, suits, and the right to property.
Fascinating how the Constitution maps out such intricate financial relationships, right down to borrowing constraints. Now let's shift gears slightly to property, contracts, and how the government interacts legally, starting with Article 294, succession to property of the Dominion and provinces. This sounds like it was mainly about ensuring a seamless continuity of governmental assets and liabilities right after independence.
Yes, Article 294 is indeed a vital transitional provision, primarily concerned with legal continuity at the moment the Constitution came into force. Its core concept is the automatic devolution or transfer of all property, assets, rights, liabilities, and obligations from the pre-Constitution entities, namely the Dominion of India and the Governor's provinces, to their successor entities under the Constitution, which were the Union of India and the corresponding states, initially Part A states.
So everything just carried over automatically.
Pretty much. It ensured that there wasn't a legal vacuum. Everything owned by the Dominion of India on January 26, 1950, vested in the Union. Everything owned by, say, the province of Bombay vested in the state of Bombay. Similarly, contracts made by the Dominion became Union obligations, and provincial contracts became state obligations. This was absolutely critical to prevent chaos and endless disputes over who owned what or who owed whom, especially given the added complexity of making adjustments necessitated by the partition of India, which the article also accounts for.
So no need for new deeds or contracts. It was an automatic legal transfer.
Exactly. The object was to ensure a smooth, orderly transfer of governmental assets and liabilities, maintain legal continuity, and provide a clear legal basis for the new union and state governments to assume their inherited rights and responsibilities. For instance, a government building owned by the Dominion in Delhi automatically vested in the union, and a contractual obligation entered into by the former Madras province seamlessly became the liability of the new state of Madras. Legal disputes that arise today sometimes involve tracing the lineage of property ownership or liability back to these pre-Constitution entities under Article 294. The legal maxims here are the doctrine of state succession and the principle of legal continuity of government.
Article 295 seems to be a similar idea, but focuses specifically on the succession related to the former Indian states, the princely states. That must have been even more complex given the sheer number and diversity of them, each with their own unique histories and assets.
Article 295 was indeed a critical piece in that complex puzzle of integrating hundreds of diverse princely states into the new Indian Union. Its core concept deals with the succession to the property, assets, rights, liabilities, and obligations of these former Indian states, which often became Part B states initially.
How did it decide who got what, the union or the state?
The key difference from 294 was the functional criterion it applied. Devolution to the union or to the corresponding state depended on whether the purposes for which the property was held or the rights accrued or the liabilities were incurred related to matters that fell under the union list in the Constitution's 7th schedule, or whether they related to other matters, implicitly state or concurrent list matters. Furthermore, this devolution was explicitly subject to any specific agreements that had been entered into between the government of India and the ruler of the Indian state during the process of accession or integration.
So the nature of the asset or liability determined its destination. If it served a federal purpose, like defense or railways, the union took it. If it served a local or general purpose, the corresponding state inherited it, unless an agreement said otherwise.
Exactly. Clause 1 stipulated that property and assets held, or rights, liabilities, and obligations incurred by a former Indian state for purposes which, from the Constitution's commencement, became Union list purposes, would vest in the Union, subject always to any specific agreement. Clause 2 then stated that, subject to any such agreement, all other property, assets, rights, liabilities, and obligations of that Indian state would vest in the corresponding state, the state within which the princely state was integrated.
That sounds like a pragmatic way to handle a complex situation.
It was. The object was orderly devolution based on a functional distribution of responsibilities under the new constitutional framework, while also providing flexibility to accommodate specific commitments made in accession or merger agreements. For instance, a princely state's railway network or postal service, unionless subjects, would generally vest in the Union, while its palaces, administrative buildings, or lands used for general state administration would typically vest in the corresponding state government. Cases involving claims against successor governments often revolved around interpreting the nature of the pre-existing right or obligation and the specific terms of the merger covenants, like in State of Gujarat v. Vorfadali Badruddin Mitbarwala.
Article 296 covers ownerless property, the concepts of escheat, lapse, and bona vacantia. This sounds like the constitutional mechanism to prevent property from falling into a legal limbo, ensuring it's utilized for public benefit instead.
That's a very good way to describe its function. Article 296 constitutionalizes the sovereign's traditional right over property that becomes ownerless. Its core concept is that any property located within the territory of India that accrues to the government by a sheet, which happens when a person dies intestate, meaning without a will and leaves no legal heirs, or by lapse, the termination of rights, often applicable to trusts, grants, or legacies under certain conditions, or as bona vacantia, literally vacant goods, referring to property like assets of a dissolved company that has no apparent owner, such property vests in the state if it is situated within that state's territory. If the property is situated elsewhere, for example, in a union territory, or perhaps assets located abroad belonging to a defunct entity based in India, it vests in the union.
So it assigns unclaimed or ownerless property to the correct government based on location, rather than letting it just sit there unused or be claimed by anyone.
Precisely. The object is to prevent a legal vacuum where property has no owner, assign such property clearly to the appropriate governmental authority, union or state, and ensure it can eventually be administered and utilized for the public benefit. The text explicitly refers to property that would have accrued to His Majesty or the ruler of an Indian state by these methods before the Constitution, ensuring continuity of this sovereign prerogative. There's also a proviso dealing with property that was already under the control or possession of the Union or a state government before the Constitution.
Give us an example.
Okay, if a person dies in Mumbai without leaving a will or any known relatives who can legally inherit their property, like land or bank accounts, that property would escheat to the state of Maharashtra under Article 296. Similarly, if a company registered in Delhi is dissolved and leaves behind unclaimed assets, those assets would accrue as bona vacantia to the Union government. This continues common law principles under a clear constitutional framework. Cases like Pierce-Leslie and Kolkoi Videria Violet Outreloni Wapshare affirm bona vacantia as an attribute of sovereignty.
Article 297 deals with maritime resources vesting in the Union. This seems hugely significant, asserting national control over potentially vast economic and strategic resources found offshore and aligning India's stance with international law.
Article 297 is indeed hugely significant, both economically and strategically. Its core concept is a clear constitutional declaration. All lands, minerals, and other things of value underlying the ocean within India's territorial waters, or its continental shelf, or its exclusive economic zone, EEZ, vest in the Union. Furthermore, it states that all other resources within the EEZ also vest in the Union.
So everything of value under the sea and all resources in the EEZ belong exclusively to the Union government.
Yes, exclusively. The article makes them Union property, to be held for the purposes of the Union. Crucially, Clause 3 states that the limits of these maritime zones, the territorial waters, the continental shelf, and the EEZ shall be such as may be specified from time to time by or under any law made by Parliament. This asserts national control over these vast offshore resources and aligns India's domestic legal position with its rights and obligations under international law, particularly the UN Convention on the Law of the Sea, UNCLOS.
What's a practical implication of this vesting?
The object is to establish unambiguous Union control over these vital resources, provide a clear legal basis for their regulation, exploration, and exploitation, and ensure that the benefits accrue to the nation as a whole. This means, for example, that it's the Union government, not coastal states, that grants licenses for offshore oil and gas exploration in the continental shelf, or EEZ. Any revenue from such activities accrues to the Union. Similarly, the Union regulates deep-sea fishing and other economic activities in the EEZ.
And Parliament defines the zones.
Yes, Parliament implements Clause 3 by enacting laws like the Territorial Waters, Continental Shelf, Exclusive Economic Zone, and Other Maritime Zones Act 1976. This act defines the limits, typically 12 nautical miles for territorial waters, 200 nautical miles for the EEZ, and the extent of the continental shelf in accordance with international norms. Article 297 constitutionally underpins India's sovereign rights over these maritime zones and their resources, both living and non-living. The relevant doctrines here include sovereign rights over maritime zones, the doctrine of the continental shelf, and the concept of the Exclusive Economic Zone, EEZ, as national property.
Article 298 discusses the power to carry on trade, etc. This sounds like it legitimizes the government's role not just as a governor, but also as an economic actor, perhaps even an entrepreneur, moving beyond just traditional governance functions. Is that right?
That's exactly right. Article 298 clarifies and explicitly expands the scope of the executive power of both the Union and the states. It states that their executive power extends to carrying on any trade or business and also to the acquisition, holding, and disposal of property and the making of contracts for any purpose.
So it's a broad power to engage in commercial activity.
Very broad. It provides the constitutional authority for governments to enter the economic arena, set up public sector enterprises, engage in commercial transactions, manage property like any other owner, and enter into contracts for a wide range of purposes, not just those strictly related to sovereign functions. This legitimizes the government's role as an economic actor, which is crucial in a developmental or welfare state context.
Is this power unlimited?
No, there's an important qualifier. The exercise of this executive power, particularly in trade and business, is subject to the respective legislative competence of Parliament and the state legislatures. The provisos to Article 298 make this clear. The Union's executive power to trade or contract in matters where a state legislature also has power, i.e. concurrent list, or even state list if Parliament hasn't occupied the field, is subject to legislation by the state. Conversely, a state's executive power in matters where Parliament has legislative power, Union list or concurrent list, is subject to legislation by Parliament.
So while the executive can act, the legislature still holds the ultimate regulatory authority based on the distribution of powers.
Precisely. The object is to affirm the government's capacity for commercial and economic activities, providing constitutional authority for the public sector, while ensuring this power operates within the constitutional framework of legislative powers distribution, Articles 246, 254, etc.
Give us some examples.
Examples abound. The union running public sector undertakings like banks, insurance companies, or strategic industries, a state government operating mining corporations, state transport undertakings, or managing state-owned lands commercially, the government of India entering into large defense procurement contracts, or a state government acquiring land to build a hospital or industrial park. All these activities derive their constitutional basis from Article 298. The Supreme Court, even before this article was amended to its current form, recognized in Rai Sahib Ramjawaya Kapoor and Ors v. State of Punjab that executive power wasn't confined only to implementing laws, but could extend to trade and business activities, provided they weren't prohibited by law. Later cases like Unravel v. Government of Tamil Nadu considered activities like state lotteries as potentially falling under trade or business for the state under this article.
Article 299 focuses specifically on government contracts, laying down mandatory formalities and also providing personal immunity for government officials involved. This seems crucial for protecting public funds and allowing officials to act without fear of personal liability.
Yes, Article 299 serves these two critical purposes. Its core concept is twofold. First, it prescribes mandatory formal requirements for contracts made in the exercise of the executive power of the union or a state. These contracts must be expressed to be made by the president for union contracts or by the governor for state contracts, and they must be executed on behalf of the president or governor by persons who are duly authorized to do so.
So specific wording and authorized signatories are essential.
Absolutely. Second, Clause 2 provides a vital shield of personal immunity. It states that neither the president nor the governor shall be personally liable in respect of any contract executed for the purposes of the Constitution. Furthermore, any person executing such a contract on their behalf is also not personally liable.
So if a government official properly signs a contract according to these rules, they can't be personally sued if something goes wrong with the contract. The liability rests solely with the government.
Exactly. The liability, if any, arises from the contract, rests with the government, union, or state, not the individual officer acting in their official capacity, provided the formalities were followed. The object of these provisions is clear. Safeguard public funds by ensuring contracts are made formally and with proper authority, clearly identify the contracting party as the government itself, and protect public servants from personal litigation arising from bona fide actions taken in their official duty, allowing them to function without undue fear.
Are these formalities strictly enforced? What if they aren't followed?
The Supreme Court has consistently held that the provisions of Article 299 regarding formalities are mandatory, not merely directory. This means that a contract which does not comply with these requirements, for instance, if it's not expressed in the name of the president-governor or signed by an unauthorized person, is generally considered void and unenforceable against the government. This was established in landmark cases like KP Chowdhury v. State of MP and reiterated in Union of India v. Al Ralia Ram, which stressed that both the expressed to be made by and executed on behalf of elements are crucial.
So a failure to follow the rules can mean the contract isn't legally binding on the government.
Generally, yes, in terms of direct contractual enforceability. However, even if a contract is void under Article 299, courts might sometimes grant equitable relief based on principles like quantum merit, payment for services rendered, or Section 70 of the Indian Contract Act, obligation of person enjoying benefit of non-gratuitous act, to prevent unjust enrichment. But the core principle remains. Strict adherence to formalities is necessary for a valid government contract. As held in State of UPV Murari Lal and Brothers Ltd., there can be no implied contract with the government if the mandatory formalities are not met. The key doctrines here are formalities of government contracts, ultra vires for unauthorized acts, and personal immunity of public servants.
Article 300 deals with suits and proceedings. This article seems fundamental for establishing the rule of law for the government itself, ensuring it's not above the law and can be held accountable in courts, just like anyone else.
That's precisely its significance. Article 300's core concept establishes the legal personality of the union and state governments for the purpose of litigation. Clause 1 explicitly states that the government of India may sue or be sued by the name of the Union of India, and the government of a state may sue or be sued by the name of the state, for example, State of Maharashtra. This grants them the capacity to be parties in legal proceedings.
So they are legal entities that can go to court. But what about their liability? Can they be sued for anything?
This is where the historical link comes in. Article 301 also provides the basis for determining the substantive liability of the government. It states that the union or a state can sue or be sued in the like cases as the Dominion of India and the corresponding provinces or the corresponding Indian states might have sued or been sued if this constitution had not been enacted.
So the liability framework is initially based on the situation just before the Constitution. That sounds complicated.
It does, and it connects back to the historical position of the Crown and the East India Company in India. Essentially, it meant that the post-Constitution government's liability, particularly in torts, civil wrongs, was initially pegged to the liability of the pre-Constitution entities, which itself was based on complex common law principles, including the doctrine of sovereign immunity.
Sovereign immunity, the idea that the king can do no wrong. How did that play out?
Historically, a distinction was often made between the sovereign functions of the state, like defense, administration of justice, for which it couldn't be sued, and non-sovereign or commercial functions for which it could be. The pre-Constitution case of Peninsular and Oriental Steam Navigation Company v. Secretary of State for India, 1861, is a classic example of this distinction. After the Constitution, the Supreme Court initially seemed to move away from strict sovereign immunity in cases like State of Rajasthan v. Instituati in 1962, holding the state liable for the tortious acts of its servants committed during non-sovereign functions, in that case, the rash driving of a government jeep driver.
That sounds like progress towards accountability.
It was. However, a later case, Kasturi Lal Ralia Ram Jain v. State of UP, 1965, caused considerable confusion. It appeared to revert to a stronger application of sovereign immunity, absolving the state from liability for the negligence of police officers in seizing gold, deeming it a sovereign function. This decision was heavily criticized for being out of step with a modern welfare state.
So where does the law stand now? Has the concept of sovereign immunity eroded?
Thankfully, yes. The Kasturi Lal ruling has been significantly diluted, if not practically overruled, by subsequent Supreme Court judgments. Cases like Ennajinder Rawankam v. State of AP, 1994, and Common Cause, a Registered Society v. Union of India, 1999, have strongly advocated for greater governmental accountability, emphasizing that in a welfare state, the distinction between sovereign and non-sovereign functions is increasingly blurred and often irrelevant. The prevailing judicial trend now strongly favors holding the state vicariously liable for the torts committed by its employees in the course of their employment, significantly curtailing the traditional defense of sovereign immunity. Crucially, Article 301 also adds that this historical basis of liability is subject to any provisions which may be made by Act of Parliament or of the legislature of such state. This empowers legislatures to explicitly define and modify the extent of government liability by law. Although comprehensive legislation on state tort liability hasn't fully materialized, the key doctrines are sovereign immunity and its erosion, vicarious liability of the state, rule of law, and government as a juristic person.
Finally, in this group, Article 300A, right to property. This isn't a fundamental right anymore, but it's still a crucial constitutional protection against arbitrary executive action regarding property, representing a fundamental shift in India's constitutional history.
Absolutely. Article 300A is hugely significant, even though it's placed outside the Fundamental Rights chapter, Part 3. Its core concept, introduced by the 44th Amendment in 1978, which simultaneously deleted the original fundamental right to property under Article 19(1) and Article 31, mandates a simple but powerful principle. No person shall be deprived of his property, save by authority of law.
So the government cannot take away someone's property just by an executive order or on a whim. It needs a specific, valid law to do so.
Precisely. That's the essence of the protection it offers. It acts as a crucial safeguard against arbitrary expropriation by the executive. Let's break down the ingredients. No person includes citizens and non-citizens, natural and juristic persons, like companies, shall be deprived of his property is interpreted broadly, covering not just outright taking acquisition, but also actions that substantially interfere with the enjoyment of property. Property itself is also interpreted broadly, and the crucial part is saved by authority of law.
What does authority of law mean here? Just any law?
No, it means a validly enacted law passed by a competent legislature. Furthermore, judicial interpretation has established that the law itself must be constitutional. It cannot violate other constitutional provisions like Article 14, equality, or Article 21, right to life and personal liberty, which can sometimes be linked to livelihood derived from property. The law must also be non-arbitrary and generally provide for a fair procedure.
So it's still a constitutional right, just not a fundamental one. What are the practical implications of this shift? And does authority of law imply compensation must be paid?
The shift from a fundamental right means challenges are typically made under Article 226 in high courts, rather than directly under Article 32 in the Supreme Court for fundamental rights violation. And the grounds for challenge might be slightly different. The most debated aspect is compensation. Unlike the old Article 31, Article 300A doesn't explicitly mention compensation. However, the Supreme Court has progressively read into the requirement of authority of law the principle that for outright acquisition of property, the law must generally provide for reasonable compensation.
So compensation isn't explicitly guaranteed, but courts often require it.
Yes, particularly in cases of acquisition. The reasoning often links back to Article 14, arguing that depriving someone of property without fair compensation would be arbitrary and thus violate the authority of law requirement. The landmark case KT Plantation, PVT, LTD, and Amir, State of Karnataka, 2011, was crucial here. The court held that the right to property under 300A is not just a constitutional right, but also a human right. It stated that authority of law means the law must be fair, just, and reasonable, and in the context of acquisition, this often implies the payment of reasonable compensation.
That's a very important development.
It is. More recently, in Vithadevi v. State of Himachal Pradesh and Ors, 2020, the Supreme Court strongly reiterated the importance of Article 300A, ruling that the state cannot forcibly dispossess a citizen of their private property without following due process of law and then claim ownership through adverse possession. It called such action a violation of both human rights and the constitutional right under 300A. So, while not a fundamental right, Article 300A provides robust protection against arbitrary state action concerning property, underpinned by the rule of law and the requirement of a valid, non-arbitrary legal process, often including compensation for acquisition. Key doctrines include rule of law, eminent domain, exercised only through law, and the distinction between deprivation and mere restriction of property rights. #H6, trade, commerce, and intercourse within India.
Now let's explore Part 13th of the Constitution, which deals with trade, commerce, and intercourse within India. This whole part seems designed to ensure India functions as a single economic unit, breaking down internal barriers. Article 301 in particular sets the stage for this economic unity, almost like a declaration of a national common market. What's a fundamental principle here?
Article 301 is indeed the cornerstone of Part 13. Its core concept is a broad declaration of economic freedom within the country. It states very simply, subject to the other provisions of this part, trade, commerce, and intercourse throughout the territory of India shall be free.
So free movement of goods, services, people involved in trade across state lines.
Yes, that's the general idea. It aims to foster economic unity and prevent the kind of internal economic barriers or balkanization that could fragment the national market. Trade, commerce, and intercourse is interpreted broadly. It covers not just the movement and exchange of goods, but also potentially the transmission of intelligence, the movement of people involved in commerce, and maybe even intangibles like ideas across state borders or within states, as long as it relates to trade. The object is clearly to dismantle internal trade barriers, promote economic integration, and ensure the free flow of goods and services, which is vital for national prosperity.
But it says subject to the other provisions of this part, so it's not an absolute freedom.
Exactly. That's the crucial qualifier. It's a general guarantee binding on both the Union and the states, but it's not absolute. Articles 302, 303, 304, and 305, which follow, lay down the exceptions and qualifications to this broad principle of freedom.
I can see how such a principle would be central to building a unified nation economically. What happens if a state, or even the union, tries to impose restrictions that seem to hinder this free flow? How is this freedom protected?
That's where the Supreme Court has played a absolutely critical role in interpreting Article 301 and balancing it against permissible regulations. The interpretation has evolved over time. Two early landmark cases are key here. First, Atibori Tiko Ltd v. State of Assam, 1961. The court held that Article 301 is violated if a tax or regulation places a direct and immediate restriction on the free flow or movement of trade. This established the direct and immediate effect test.
So only direct impediments violate the freedom.
That was the initial view. But then came Automobile Transport Rajasthan Ltd v. State of Rajasthan, 1962, which refined the Atibori ruling. The court here upheld the validity of compensatory taxes. These are taxes levied by a state for the use of facilities it provides, like roads, bridges, or market facilities. The reasoning was that such taxes are not restrictions on trade, but rather payments for services or facilities provided to facilitate trade. Therefore, they don't violate Article 301.
The compensatory tax doctrine. That makes sense. Paying for using the road isn't stopping you from using the road.
Exactly. This doctrine has been central to interpreting Article 301 ever since. More recently, a larger bench in Jindal Stainless Ltd in Annur State of Haryana and Ors, 2017, revisited and reaffirmed the compensatory tax doctrine. They emphasized that the working test is whether a tax is genuinely compensatory in nature, meaning there's a reasonable relationship between the tax and the facilities provided, or whether it's merely a pretext for restriction on trade using the guise of compensation to actually hinder free movement.
Okay, so Article 301 declares freedom, but allows for compensatory taxes. Then Article 302 allows Parliament to impose actual restrictions on this freedom. This suggests that the national interest can, at times, override absolute economic freedom.
Yes, Article 302 explicitly grants Parliament this power to curtail the freedom guaranteed by Article 301. Its core concept is that Parliament can, by law, impose such restrictions on the freedom of trade, commerce, and intercourse, whether between states, interstate, or within a state, intrastate, if doing so is required in the public interest.
So Parliament gets to decide when the broader public good outweighs the need for completely free trade.
Precisely. It allows the national legislature to regulate or restrict trade for overarching national concerns. The justification must always be required in the public interest. This power might be used, for instance, to manage scarcity of essential goods during a national emergency, to address serious public health concerns related to certain products, to implement national economic policies, or perhaps for security reasons.
And public interest is the key justification. Is that reviewable by courts?
Yes, public interest is the constitutional justification. While courts generally give significant weight to Parliament's judgment on what constitutes public interest, the necessity and reasonableness of the restriction are, in principle, subject to judicial review. However, the bar for striking down a parliamentary law made under Article 302 on grounds of lacking public interest would likely be quite high. Examples could include Parliament enacting a law temporarily restricting the interstate movement of food grains during a severe national shortage to ensure equitable distribution, or a law completely prohibiting the trade of certain hazardous materials across the country for public safety reasons, both justified by invoking public interest under Article 302.
Article 303 then brings in further restrictions, but this time it seems to be restrictions on the legislatures themselves, prohibiting interstate bias or discrimination in trade laws. This sounds like a vital safeguard against economic protectionism or favoritism by either Parliament or state legislatures.
Article 303 is indeed a crucial anti-discrimination clause, acting as a check on the powers granted elsewhere, including Article 302. Its core concept prohibits both Parliament, despite the power given in Article 302, and state legislatures from making laws relating to trade and commerce that give preference to one state over another or that discriminate between states.
So a level playing field is mandatory. No favoritism allowed.
Exactly. Clause 1 makes this clear. It starts with notwithstanding anything in Article 302, meaning even Parliament's power to restrict trade in the public interest cannot be used to create discriminatory preferences between states. Neither Parliament nor a state legislature can, by virtue of any entry relating to trade and commerce in the legislative lists, make a law that gives preference to one state or discriminates against another.
Is there any exception to this strict non-discrimination rule?
Yes, there's one very limited exception provided in Clause 2. This exception applies only to Parliament, not state legislatures. Parliament can make a law that gives preference or discriminates between states if it declares in that law that such measures are necessary specifically for dealing with the situation arising from the scarcity of goods in any part of India.
So only Parliament, only for scarcity, and only with an explicit declaration. That's quite a narrow window.
Very narrow. The overall object of Article 303 is clearly to prevent regional economic advantages or disadvantages being created by legislation, foster fiscal equity between states, and prevent the kind of economic balkanization that plagued other federations. For example, if Parliament passed a law setting higher central excise duties on goods produced in State A compared to identical goods produced in State B, that would likely violate Article 303(1). Similarly, if a state passed a law prohibiting the export of a locally produced commodity to all other states except one particularly favored neighboring state, that would also be discriminatory and violate 303(1). However, if there was a severe localized famine, Parliament could potentially, with an explicit declaration under 303(2), prioritize the movement of food supplies to the most affected states, even if it temporarily appeared discriminatory against others. Cases like State of Madras v. Natarajan Mudaliar dealt with nuances like whether varying central sales tax rates reflecting underlying state sales tax rates amounted to discrimination by Parliament. The court held it didn't in that context.
Okay, so 301 guarantees freedom, 302 allows Parliament to restrict it in public interest, and 303 prevents discriminatory restrictions. What about the states? Article 304 seems to allow states to impose certain restrictions on trade, but with that crucial safeguard, prior presidential sanction. This sounds like it empowers states to protect their local economies or public interest, but with a vital check from the Union to prevent misuse or protectionism.
Article 304 does precisely that. It carves out specific powers for state legislatures to impose certain limitations on the freedom of trade, despite the general prohibition in Article 301 and the non-discrimination rule in Article 303. Its core concept is twofold. First, it allows states to impose non-discriminatory taxes on goods imported from other states or union territories. Second, it allows states to impose reasonable restrictions on trade, commerce, and intercourse with or within that state, provided these restrictions are in the public interest.
But there's a catch, right? The presidential sanction.
Yes, a very important catch. While Clause A deals with non-discriminatory taxation, Clause B, which allows for reasonable restrictions in the public interest, has a critical proviso attached. This proviso states that no bill or amendment for imposing such reasonable restrictions under Clause B can be introduced or moved in the state legislature without the previous sanction of the president.
So states can tax goods coming in, but crucially, not at a higher rate than similar local goods. And they can impose other restrictions on trade, like quality controls or even prohibitions for public health, but only if they are reasonable in the public interest, and that the president has approved the bill before it's even introduced in their legislature.
Exactly. Clause A ensures fiscal neutrality. Imported goods shouldn't be disadvantaged compared to local goods through discriminatory taxation. So if State A imposes a 5% sales tax on locally manufactured bicycles, it can impose the same 5% tax on bicycles imported from State B, but it cannot impose, say, a 10% tax just because they are imported. That would violate 304A.
And Clause B.
Clause B allows for non-fiscal restrictions needed for the public good within the state. For example, a state might want to restrict the import of cattle from a neighboring state affected by a contagious disease to protect its own livestock, a public health measure. Or a state might want to regulate or even prohibit the sale of liquor for reasons of public order or health. Such measures, if they restrict trade, would fall under 304B and would require 1, to be reasonable, which is judicially reviewable, 2, to be in the public interest, and 3, crucially, the bill proposing them needs prior presidential sanction.
That prior presidential sanction seems like a very strong safeguard against states creating arbitrary or protectionist barriers disguised as reasonable restrictions.
It is. It acts as a vital check by the union executive, ensuring that state laws potentially restricting interstate trade are vetted at the national level for reasonableness and public interest before they proceed. The Supreme Court has frequently interpreted Article 304. Cases like Kalyani Stores v. State of Orissa and Ors confirm that non-discriminatory countervailing duties on imported goods are permissible under 304A. Jalal Manila and Company v. State of MP emphasized the mandatory nature of the prior presidential sanction under 304B. And Video Electronics PVT Ltd v. State of Punjab established that if similar local goods are completely exempt from tax, then imported goods cannot be taxed under 304A.
Article 305 is next. Saving of existing laws and laws providing for state monopolies. This sounds like it ensures legal stability for older laws and also constitutionally legitimizes the state's role in certain economic sectors through monopolies.
Article 305 serves exactly those two purposes. It's a crucial saving clause. Its core concept is dual protection. First, it shields existing laws, meaning laws that were in force immediately before the commencement of the Constitution, from being challenged under Article 301, freedom of trade, and Article 303, non-discrimination, unless the president issues an order directing otherwise.
So, pre-Constitution laws related to trade got a general pass, unless the president specifically reviewed and changed them.
Correct. This prevented immediate chaos by invalidating numerous existing regulations. Second, and perhaps more significantly for ongoing relevance, Article 305 saves laws relating to state monopolies. It explicitly states that nothing in Articles 301 or 303 shall affect the operation of any law made before the Constitution First Amendment Act, 1951, or prevent Parliament or a state legislature from making any law relating to carrying on by the state or by a corporation owned or controlled by the state of any trade, business, industry, or service, whether to the exclusion, complete or partial, of citizens or otherwise. This directly links to Article 19.2, which allows the state to create monopolies in the public interest as a reasonable restriction on the fundamental right to practice any profession, trade, or business.
So, old laws are generally safe, and importantly, any law, old or new, that establishes a state-run business, even if it excludes private players completely, is protected from being challenged as a violation of the general freedom of trade under Article 301.
Exactly. The object is twofold. Ensure legal continuity by protecting pre-Constitution laws from automatic invalidation under the new trade freedom principles, subject to presidential review, and provide clear constitutional sanction for the creation and operation of state monopolies, recognizing the state's role in certain sectors of the economy for public welfare or strategic reasons.
Give us an example.
For the first part, a pre-1950 state law imposing certain procedural requirements or fees on interstate traders might continue to operate under the protection of Article 305, even if arguably burdensome, unless the president intervenes. For the second part, if a state legislature passes a law granting the state government or a state-owned corporation a complete monopoly over, say, the wholesale trade of liquor or the operation of certain public utilities within the state, that law creating the monopoly is protected by Article 305 from being challenged on the grounds that it violates the freedom of trade guaranteed by Article 301. Landmark cases like Sagir Ahmad v. State of UP, which was decided just before the First Amendment clarified the position on monopolies, and Akadasi Patan v. State of Orissa extensively examined the scope and limits of permissible state monopolies under the constitutional framework, including the interaction between Article 19.6 and Part 13.
Article 306, again, is a repealed article. Relating to Part B states, what was its purpose briefly?
Yes, Article 306, titled Power of Certain Part B States to Impose Restrictions on Trade and Commerce, was repealed by the Constitution's Seventh Amendment Act, 1956. Its original purpose was purely transitional. It allowed those former princely states, which constituted Part B states, to continue levying certain taxes or duties on goods entering or leaving their territories, which they were lawfully levying before the Constitution for a maximum period of 10 years. This was intended to give them time to adjust their fiscal systems.
So another temporary measure for integrating the diverse financial systems of the princely states.
Exactly. The president had the power to direct modifications or termination of these taxes earlier. Its repeal in 1956, along with the reorganization of states, was part of the move towards establishing a more uniform national market and tax structure, rendering such special transitional provisions for Part B states unnecessary. Like 259-278, it's another historical artifact showing the step-by-step process of fiscal integration in the early years of the Republic.
And finally, Article 307. Appointment of authority for carrying out the purposes of Articles 301 to 304. This sounds like an enabling provision, allowing Parliament to create a specific body, if needed, to oversee this whole area of trade and commerce regulation.
That's precisely what Article 307 is, an enabling clause. Its core concept states that Parliament may, by law, appoint such authority as it considers appropriate for carrying out the purposes of Articles 301, 302, 303, and 304. Furthermore, Parliament can, by that law, confer on the authority so appointed such powers and duties as it thinks necessary.
So if Parliament felt that managing the complexities of interstate trade, ensuring non-discrimination, and overseeing reasonable restrictions required a specialized body, like an Interstate Trade Commission perhaps, it has the constitutional power under Article 307 to create one.
Exactly. The object is to provide a potential administrative and regulatory mechanism for the effective implementation and enforcement of the principles laid down in Part 13 regarding free trade and its permissible regulation. Its salient features are that the power to create such an authority rests exclusively with Parliament. The authority's mandate would be tied to carrying out the purposes of Articles 301 and 304, and Parliament has flexibility in conferring the necessary powers and duties.
Has such an authority ever been created?
To my knowledge, no specific overarching authority solely dedicated to the purposes of Articles 301, 304 has been established under Article 307 so far. Various regulatory bodies might touch upon aspects of interstate trade within their specific sectors, like competition law or specific commodity boards, but a general Part 13 implementation authority hasn't been deemed necessary by Parliament yet. However, the provision remains in the Constitution as an enabling power. Should Parliament ever feel that complex interstate trade disputes or the need for harmonizing trade practices requires a dedicated national body, Article 307 provides the clear constitutional sanction for creating it. It falls under the principles of administrative law and legislative delegation for enforcing constitutional provisions. #outro.
Wow, what an incredible journey that was, digging deep into some of the most, well, intricate and foundational parts of the Indian Constitution. We've really unpacked everything from how the Union makes sure states actually follow national laws, to that really delicate dance of sharing revenue, and all the way to the fundamental idea of free trade across such a diverse nation.
It really is a complex tapestry, isn't it?
It truly is. It's a testament, I think, to the foresight and maybe also the adaptability of its framers. What really stands out to me, listening back to our discussion, is this constant interplay, this push and pull between central authority and state autonomy. It seems like almost every article we touched upon involves balancing those two, all designed, ultimately, to maintain a unified yet diverse, functioning democracy.
Indeed. And if we try to connect all these intricate threads to the bigger picture, these articles aren't just dry legal text sitting in a book. They are the very sinews, the connective tissue of India's federal structure. They vividly demonstrate how a nation with such immense linguistic, cultural, and economic diversity strives for and constitutionally mandates unity in administration, finance, and commerce. They provide mechanisms for cooperation, like we saw with Articles 258 and 258A. They offer ways to address fiscal imbalances through the Finance Commission and grants under Article 275. And they lay down rules to ensure that the vast machinery of governance, both at the union and state levels, runs, well, hopefully smoothly, or at least within a defined framework. Understanding these specific provisions, their objectives, their scope, their exceptions, and crucially how the courts have interpreted them over 7 decades, truly gives you a profound insight into the why behind many governmental actions and policies you see playing out, both nationally and in your state.
So, thinking about all this, what does it all mean for you listening in? As we've seen, every single article, every amendment, like the ones repealing pretty purses or inserting the right to property differently, every court judgment refining doctrines like sovereign immunity or compensatory tax, it all shapes the daily reality of governance in India. It really raises an important, very provocative question for the future, doesn't it?
What are you thinking?
Well, in an increasingly complex and interconnected world facing challenges, the original framers couldn't possibly have fully envisioned, like climate change requiring coordinated action, or the complexities of global digital economies that transcend borders. How much more might federal systems like India's need to adapt these delicate balances of power and finance? Could we even imagine needing new articles or constitutional interpretations to address these 21st century challenges effectively? What new constitutional innovations might be needed, do you think, for the next century of cooperative governance?
That's definitely a thought to chew on. We hope this deep dive has given you a clearer, richer understanding of India's intricate constitutional framework for governance and finance, and maybe even ignited your curiosity to explore further.
Thank you for joining us on the deep dive. Until next time, keep digging.